don't really enjoy very good sanitation. So the sanitation was not at its best. Also, we didn't involve women in the governance of an environment because women were limited. Were limited in the way they got information, the way they got education, because of the culture that we enjoyed, and Mrs. Charlene will explain more on this. So essentially, we didn't have this right enjoyed as we do right now. And then we got independence, yes, in 1963. And then by the 1963, there was a semblance of structure in the way the environment was set, because we were now away from the concentration camps. We are now citizens of Kenya. And during that time, the constitution also didn't recognize this right. So hii right ya mazingira safi haikuwa katika katiba ya enye ilikuwa 1969-1963, the independence constitution. So the right was not explicitly provided for. However, this right was explained or extrapolated from the right to life. Meaning, wewe kama mwanadamu ulikuwa kuna haki ya kukua hai as a human being. You have the right to life. And because of that, it was assumed that you have the right to a clean and healthy environment from you having the right to life, from that entitlement of the right to life. And then moving forward to 1990s there, between 1990s to 2000, we saw this right being encapsulated in the EMCA Act, which is the Environment Management and Coordination Act. It provided for this right. This right, as you ukichambua zaidi, utagundua ya kwamba huwezi zungumzia haki hii bila kuzungumzia haki zingine, kama haki to maybe access of information, to participation in the governance of your environment, to policy formulations. You can't speak about this right without speaking about other rights. That's why the Constitution is largely progressive, because you need to read it wholesomely. So such rights were, however, provided in one way or another. They were provided for under the Constitution. And so someone could seek redress from the courts because maybe their environment was maybe damaged, and because of that, they suffered a health risk. It was also very difficult to access information regarding the environment. An example of this will be in the 1990s, the founder of this institution, Moi, during his regime, there was nuclear waste dumping in Kenya, in the northern parts of Kenya. And this led to various diseases, kama cancers, mimea kukufa, mifugo yetu kukufa because that is very toxic to the environment, and so people suffered a lot. And because of that development and development in international law, we got the codification of the right to clean and healthy environment in the Constitution and Article 42. And then the people wanted safety from pollution. They also wanted safety from deforestation and poaching and soil erosion, which ni momonyoko wa ardhi. So walitaka these provisions zikuwe catered for katika katiba yetu ya 2010. And then the commission obviously recommended that such be encroached in the Constitution. Also, looking at what we've had since the 2010 Constitution, we've progressed in one way or another, I would say so. We've had various cases, and we also have a court, the Environment and Land Court, that deals specifically with issues environment and issues to deal with land. And this is very progressive because you have a specific court, so you are sure that if you have an environmental issue, unaweza approach your court, na hiyo koti itashughulikia maslahi yako kama mwananchi wa Kenya aliyeathirika in one way or another by their right to environment being violated. And so that was very progressive. And the Environment and Land Court has made decisions dealing with this right to environment, has made very many decisions, and I will maybe like to look at one that happened hapa karibu na Kabarak in Nakuru. The Nakuru law courts dealt with a case, and the case essentially ilikuwa inazungumzia Gioto dump site. Sijui kama mnajua dump site iko on your way from Nakuru to Kabarak. there's a big dump site hapo. Ukipita hapo hadi there was a time I remember there were police. Ukipita hapo you could definitely tell. Kulikuwa na harufu na utasikia. You could tell that you are near Gioto dump site. So this dump site, the residents near Gioto, I think residents of Kiamunyi, approached the court wakisema ya kwamba the dump site is affecting their right to environment. So they wanted the court to declare that their right to environment, poleni, has been violated. Court ikasema ya kwamba it's true that the people managing the Gioto dump site hawakuwa na the requisite licenses to manage that dump site, and because of that there was a violation of their rights, and they upheld that right. So this is in one way an example of where the Environment and Land Court has dealt with the issue of clean and healthy environment. However, I mentioned this case because I found it very unique. In the submissions of the council presenting the residents who live around Gioto dump site, they mentioned that there were street kids when you walikuanga hapo, and thus they posed a security threat to the people who lived around Gioto dump site. And uniquely, the judgment failed to notice that these street kids pia have this right. This right also is supposed to be enjoyed by these street kids. Juu pia wao ni wananchi. They ought to enjoy the right to a clean and healthy environment. However, it didn't address that. Also, notably, the court also didn't address how this dump site is going to be dealt with, because hawakusema, okay, this dump site is maybe a problem. The problem is actually this dump site and not the management per se. So, to deal na hii dump site, tujue jinsi ambavyo tutakuwa tuna deal with the waste that we have, because as humans we will eventually need to dump waste from whatever we use. And I find that as a misfortune, or a failure of the court in one instance, which is it's a trend of the court failing to address the actual environmental damage, but dealing with the case itself. So that's something I found very unique, and something that I am learning, or a certain critique of the court. Also, we also have a case had been mentioned by the keynote speaker about lead poisoning that happened in, I think, Mombasa, which was also very progressive and very unique in the sense that it also addressed the rights in a very unique way. I will close by saying this. The environment is essentially very, very special to us humans. We can't live without the environment. A philosopher, a historian called Ali Mazrui, in one of his videos, he mentions that the environment helped us gain independence in a way because we went to the forest to hide. Akina Maumau wakifight, they went to the forest to hide. And looking at that perspective of the environment helping us and the way we treat the environment, it's actually a shame. It's actually very, very shameful of how we treat the environment, because we really don't care as much as we ought to care about how we treat the environment. And so the problem, in as much as the government ought to it has actually set various policies, we also ought to play a part in ensuring that the environment is catered for and it's kept clean for our generation and for future generations. Kwa hivyo inamaanisha ya kwamba tunapaswa kulinda mazingira yetu by ensuring we don't overconsume, ensuring that we deposit our waste properly, and we do what it takes to ensure that our environment is clean. And I think that is it. I won't delve into the international human rights framework because I acknowledge that it really doesn't serve the purpose, because I acknowledge the audience. And I will, at this point, cede the panel to my other panelists to discuss their rights with the guidance of our discussant. Thank you.
Yes, you can. Thank you so much, Njogu. That's a very well-structured presentation. And I am really pleased to see that you have structured your discussion around real-life examples. Mambo ambayo, they affect us in our daily lives as citizens of Kenya. And one of the examples you gave is something that I would like us to come back to if we have time. So next we will have Charlene Nyaboke. Charlene, welcome. And just as Njogu, please try to keep within your time.
Habari zenyu. Mimi naongelea Article 44 yenye inapea kila mtu uhuru wa kutumia lugha yake. Wacha nisome kwanza kwa Kiingereza alafu nitaeleza kwa Kiswahili. Inasema kila mtu ako na right to use language of their choice and to participate in cultural life of their choice. Kwa hivyo kama wewe ni Mkikuyu, Mkalenjin, Masai, sheria unakubaliwa right yako ya kutumia lugha yako ina protectiwa na constitution. Alafu pia unaweza jiunga na vikundi vya community yako, unaweza ungana na watu wengine bila kulazimishwa. Alafu pia unaweza participate kwa cultural practice. Kila community najua iko na itikadi ama utamaduni yao. So unaweza participate kwa cultural practices ama religious practices za community yenyu, lakini isikuwe ni kitu ambayo inaweza umiza mtu mwingine. So hapo ndo limitation iko. So nitaongelea mbeleni vile kulikuwa. Wakati kabla tupate uhuru, nini ilikuwa inafanyika? Kabla wakoloni walikuja, walitupata tukiwa na mila zetu na itikadi zetu, lakini waliona ni kama si jambo mzuri. In fact, walitaka wapush tujifundishe Kiingereza, tujifundishe utamaduni wao. Hawakuona yetu kama ni ya maana vile, yeah? So waliona kama yetu ni backward ama haingesaidia kuleta maendeleo katika nchi. So ungepata hata wakati ambapo hii constitution ya kwanza iliandikwa, hawakushughulikia mambo ya cultural rights ama community rights sana. Ilikuwa more individualistic. Ni kama wale ambao walikuwa na negotiate, walikuwa nataka waweke interest zao, hawakuwa nafikiria kuhusu jamii. Na Kenya iko na jamii mingi. Unaona tuko na 42 language groups. Na kila mtu anaongea lugha tofauti tofauti, na kila mtu ako na mila tofauti tofauti. Yeah? Na hizo zote zilikuwa zinafaa ziprotectiwe, lakini hiyo constitution haikuzingatia sana mambo kama hayo. So ungepata kuna vipengee kwa hiyo constitution ambayo ilikuwa inaongelea kuhusu mambo kadhaa ambayo ingetumika. For instance, if you are you are a Kisii or a Luya or you can apply personal law kwa kudeal na mambo kama tuseme kama kuna dispute, unaweza apply law ya kijamii hapo. Alafu pia kwa hiyo constitution walikuwa nasema Kiswahili, English itakuwa official language. So kumaanisha ungeongea lugha nyingine kwa kama ni assembly, national assembly, unafaa muongee Kiingereza. Alafu pia documents za koti kama hizi sheria, unaona kama constitution imeandikwa na Kiingereza. So haiko inaandikwa kwa lugha ambayo watu wangeweza kusoma. So kama hujui Kiingereza ama Kiswahili, unabaki tu, labda watafute mtu asaidie kuinterpret. So haikuzingatia vitu kama hizo. So kuna kesi, nitamention kesi moja, sijui kama mmesikia hii kesi ya Wamboi Otieno, SM Otieno. Kuna time alikuwa bwana yake alikufa. Alikuwa wakili akakufa. Alafu alikuwa anataka kwenda kumzika. So akitaka kumzika, yeye walikuwa wameishi Nairobi na bwana yake, alafu kulikuwa na shamba huko, alitaka amzike huko. Lakini kuna hii clan ya Umir Kager huko kwa Waluo, walikuwa wanataka wazike huyu mtoto wao Luoland. Na huku unasema sababu mmeolewa, mmekuwa mkikaa pamoja, tumzike wapi? Nairobi. Vile walienda koti, hiyo ilikuwa kabla constitution mpya ikuje, kwa sababu personal law ilikuwa inakuwa recognized. Hapa tunaona koti iliamua ikarule in favor of the clan, wakaachilia mwili iende Luoland, yeah? So unaona kuna masuala kidogo walikuwa naguzia, wana apply mambo ya culture na community, ya community rights, vitu kama hizo. So unaona culture inaguzia vitu kama lugha, vile mnaishi kama jamii, kuna hizi rights, kuna kama circumcision, kuna watu, kuna kama Waluya, kuna vile watu huenda ku bullfighting, unaona vitu kama hizo, vile tu community inaishi their way of life. So hizi vitu hazikuwa zinakuwa protected. Hata kuna vitu ambazo jamii inatengeneza kama viondo, kuna hizi shuka za Wamasai, beads. Unajua hizo vitu zinaweza ibwa na watu huko nje, alafu wanasema hao ndio wametengeneza na ni wa Kenya. Kitu kama kiondo. Unaona kuna wakati hata mwaka wa hizi 2000s Japan ilichukua kiondo ikasema kiondo ni hao ndio wametengeneza, na kiondo ni kitu ilikuwa imetengenezwa na Wakenya. Unaona? Nani ajaitu? Nani muona kiondo vile inakaa? Hata hii shuka ya Masai. Ya? Kuna vitu wazungu walichukua wakasema ni zao, alafu na ukiangalia so utapata ni communities zilikuwa hao ndo wako na hiyo knowledge ya kutengeneza hizo vitu. So constitution haikuwa inashughulikia vitu kama hizo sana. Hakuwa wanaona kama culture na language ni kitu yenye italeta umoja katika nchi. So vitu mingi zilifanyika between hiyo 1963 mpaka 2010. Kabla watengeneze hii constitution ya 2010, walienda kwa ground wakauliza wananchi, sasa mnaona tufanye aje ndo to make sure hii constitution yetu ina cater for all the members of the community. Tunaangalia kama ni wa Kisii, Waluya, tuna feel tuko represented. Wananchi wakasema mkitengeneza hii constitution tunataka tuone mnashughulikia masuala ya community rights, naona hizi customary law, to acknowledge kwamba sisi ni Waafrika na tuko na unique practices. Sisi kama wazungu tuko na mila zetu, ya. So hata kama mtaweka Kiingereza ikue one of the official languages, Kiswahili ikue national language for instance. Alafu to recognize sisi kama Waafrika ni community. So kuna hizi vitu tunafanya kama Waafrika yenye ni unique kwetu. So hizo vitu zote zikuwe zimeshughulikiwa kwa hiyo constitution mpya. Lakini wakasema pia kuna zile practices ambayo si mzuri, kama unaona ukeketaji wa wasichana. Hiyo ni jambo ambalo imeleta shida, kwa sababu utapata wasichana walikuwa na keketo alafu unalazimishwa kuolewa. So kuna vitu zenye tulikuwa tunasema ni harmful. So sheria itakubalia mfanye vitu zile ambazo ni sawa, tunakubali, lakini kama itaumiza watu kwa jamii, then hiyo cultural practice hatutafuatilia. So ndo tukasonga tukaona kabla hiyo constitution, wangapi wanajua hii jamii ya Endorois yenye ilikuwa inaishi karibu na Lake Bogoria. Kuna wakati government ilikuwa inataka kujenga game reserve hapo hivyo, alafu kuna community ilikuwa inaishi hapo. So walikuwa wanawafukuza waende mahali kwingine, na wako alafu hiyo watengeneze mahali penye tourists watakuwa wanakuja kuona hiyo lake. Lakini kuna community ilikuwa inakaa hapo inafanya mambo kadhaa, wangeomba hapo, kuna cultural practices zilikuwa zinafanyika hapo. So kwa sababu constitution ya kwanza haikuwa ina recognize community rights, ilibidi hii jamii wapeleke kesi hadi Gambia penye African Commission for People and Human Rights isikize, ndio isemekana kwamba haki zao hazijashughulikiwa. Hatukuwa Kenya haingesikiza sababu constitution haikuwa na hiyo kipengele ya kushughulikia community rights. So tukasonga mbele, hii mambo yote ikasababisha sasa hii article 44 kutokezea. So article 44 venye nimewaambia inapatia members, kila mtu, the right to use a language of their choice and to participate in cultural life of their choice. Na kama una belong to a community with other members of the community, you can use your language, yeah? Kama wewe ni Mkikisii, ongea Kikisii. Kama wewe ni Mkale, ongea Kikalenjin. Ama kama wewe umefeel wewe ni Mkisii but unataka kujiunga na Wakalenjin, ni sawa. hakuna mtu atakulimit, lakini hauwezi lazimisha mtu kufanya any cultural practice ama right yenye itamuumiza ama itaham members of the community. Yeah? So for instance, naweza wapea kesi moja. Kuna daktari anaitwa Daktari Tetu, alienda koti akasema FGM kama msichana ako na miaka 18 na amekubali anataka kufanyiwa hiyo right, yani amekubali, hana shida, mbona mkataze? Kuna watu wenye wanakubali, lakini constitution unajua inatetea haki za binadamu. Haiwezi kubalia kitu kama hiyo kwa sababu utakuwa una justify ya wrong. Kuna watu wamekufa sababu ya FGM. Yeah? Kwa vijana naona inafanyika, lakini kuna siku hizi naona hadi wanapelekwa hospitali. Ile njia ya kitambo ya kufanya wanakimbia uchi alafu unasikia watu wanakufa. Maybe kisu yenye ilitumiwa pia si wamefundisha hata hao watu njia ya kufanya ikuwe safe. So hii koti ilisema haiwezi kubalia hiyo FGM ifanyike sababu in fact walisema hiyo wametengeneza sheria ya kupinga mambo kama FGM kwa wasichana sababu ilikuwa inasababisha maafa mengi, haikuwa na benefits kwa community vile. Lakini kuna vitu ambazo tumeprogress after hii constitution yetu ikuwe in terms of culture na mambo ya expression. Tulisema English ndio ilikuwa tu official language. Hata shule ukienda ungepata mother tongue haifundishwi. Lakini kuna policies zenye wanaweka kwa education. CBE labda italeta mabadiliko kwa sababu wanasema mother tongue pia ikuwe included among languages zenye zinafundishwa. Ufundishe Kiswahili, ufundishe Kiingereza, lakini consider pia watu wajue roots zao penye wametoka. Ongeza tunangoja tuone kama itafanyika, juu bado naona English inatumika zaidi. Lakini tunaona kuna masiku kama siku za utamaduni, tuko na utamaduni day, si ndio? Naona tunasherekea culture, tuna recognize heroes wa different communities, wale ambao walipigania independence saizi, si kama kitambo. Alafu pia niliona juzi Gen Z wakienda State House waliomba na Sheng. Hiyo ni kitu niliona president amefurahia sana. So saizi si lazima ikue English pekee. Wameanza kurecognize kuna lugha zingine zimeanza kutokezea. Na kwa koti pia ukienda kuna kesi ambazo unapata mshtakiwa kama haelewi Kiingereza ama Kiswahili, wanatafuta mtu ambaye anazungumza labda ile lugha yake alafu wanainterpret ndio ajue kama ameshtakiwa ni makosa gani, ndio aweze kukubali ama kukataa. So naweza sema mbeleni hawakuwa wanashughulikia sana, hawakuona kama mambo ya culture na mambo ya community ni important, lakini walikuja kuona ili ufanye Kenya hii nchi iende mbele, to recognize Kenya iko na community tofauti na kila mtu ako na itikadi ama desturi ambazo zinasaidia nchi kukua nchi vile iko. So usipolinda hizi haki itamaanisha kuna watu watafeel wako left out. Tunaona kuna hizi communities ambazo ni indigenous, nimesema hiyo moja ya Endoreis. Kuna hii kesi ya Ogek, sijui kama Ogek wenye walikuwa nafukuzwa Mau Forest for instance, walikuwa naambiwa watoke huko sababu wanataka kuprotect environment. Na unajua Ogek ni wale wa hunters and gatherers, wanaishi huko, wanafanya hapo ndo wanatoa chakula. Basically lifestyle yao ni kuishi kwa forest, na so ukiwafukuza unafukuza waende wapi? Nairobi. Watasurvive. Na wamezoea penye miti iko, maji, alafu naambiwa waende. So hiyo kesi ilikuwa hapo 2009 to 2010. Sasa after constitution ilikuwa serikali ilifaa ilipe hawa watu na irecognize hawa watu ni indigenous community, but tunaona cause hii kitu haikuwa mbeleni wanatilia manani, imekuwa pia vigumu kucompensate hawa watu. Bado hawaja comply kwa hizo orders mingi zenye koti ilipeana, hiyo African Court. Yeah, so hiyo ndio naweza sema tumesonga mbele kiasi, but utapata ukiangalia decisions zingine za koti zenye zimefanyika hivi recently after hiyo constitution ipitishwe, kuna zenye zinaturudisha mbele ama nyuma. Kuna moja yenye naongelea kuhusu shule na mambo ya religion. Unaona kuna shule ambazo kama ni shule ya kanisa, utapata shule ya kanisa inataka ilazimishe kama mwanafunzi for instance ni Muislamu asivae hijab.
Excuse me, Shali, sorry to barge in, but please try to wrap up your remarks.
Anamalizia. So in conclusion naweza sema tumesonga mbele. So tunasonga mbele na natumai tuta-improve ku-protect culture ama itikadi za jamii tofauti tofauti humu nchini.
Thank you very much. Thank you, Charlene, for discussing that very topical issue. One would have imagined that some of these issues have been put to rest, but as you have clearly shown, especially in reference to the tattoo case, that we still have there are still some outstanding questions to answer, particularly in relation to whether what the law says in books is actually what is happening in action or in practice. So next up, we have let's see, Teresia Wanjiko, who is going to speak on Article 45. And I will ask you, Teresia, just like the previous speakers, to try to keep within the time allocated. Thank you and welcome.
Thank you very much. Thank you very much. Good afternoon. Mkoaje? Msiboeke sana. Naongelea kuhusu familia sasa. Naongelea kuhusu familia, ndoa. Okay? So ongelea familia, kasiongelelei ndoa, culture, utamaduni, naona. So family is an important part of the society. Family is very important. Familia ndio kila kitu, hata kwa wazee wenye wako hapa. Family is very important. Kwa watoto, kwako kama wewe binafsi, unajua family is very very important. So nitaanza kwa kusema kitambo, before koloni wafike, familia ilikuwa kwa regulated na different cultural norms. Naona kama ni Mkikuyu utafanya ndoa kulingana na Wakikuyu. Kama ni Mkalenjin utafanya ndoa kulingana na Wakalenjin. Na utakuwa ukilea familia, ukikuza familia, ukilea watoto kulingana na mila na desturi za Wakalenjin, Wakikuyu, Waluo, hivyo. Na familia ilikuwa inakuza society. It used to regulate the society a lot. We had a lot of things that started from the family. Kama kulea watoto, kukuza mtoto, kumlea, unaanza kumlea kutokana na familia. Na akianza sasa kuinteract na watu wengine wa society, unaona sasa ameanza bring the family values, unaona. So vile koloni walifika, they tried to suppress. Walikuwa jaribu kufinyilia sahi familia kabisa. Na vitu zingine za Wakenya Kenya walikuwa tunafanya. We used to have polygamy, unaona. Mwanaume wa Mwafrika anaambiangwa haizika na bibi mmoja, unaona. Na kwa bibi wengi, watoto ni wengi. And then tulikuwa na hii mambo ya watoto. Children are a very important part of the family. Watoto ni kitu important sana. So if you cannot procreate, kama huwezi pata mtoto, we have to find a way vile tutakufanya wewe upate nini? Mtoto. So tulikuwa na something so common among the Kalenjins, Nandis, Kikuyus, called woman-to-woman marriages. Mimi kama mwanamke naenda napata mwanamke mwingine, anambia kuja sasa unifanye nini? Nizalie watoto. Na watoto si wako, ni nani? Ni wangu na bwanangu. Unanielewa? Mtoto si wangu, mtoto si wake, mtoto ni wangu na bwanangu. Sasa vitu kama hizo ndo zilikuwa zinakasirisha wakoloni sana, juu anashangaa sasa hii ni nini, unaona? Hakuna venye a man can get married to 2 or more wives. So they tried to suppress it. Walikuwa jaribu kufinyilia kabisa. Wakajaribu kuleta laws, wakajaribu kuleta, wakoloni walileta Christianity, and Christianity advocates for monogamy. Yani mwanamke mmoja, mwanaume mmoja, unaona? So kwa hivyo walikuwa jaribu regulate this thing. Hakuna venye utakuwa polygamous. There is no many wives, no many children, no woman to woman marriages, na hizo ndo zilikuwa the pride. Yani ndo tunajivunia kama Wakenya. Mimi najivunia kama Mkalenjin kuolewa na mwanamke mwingine ili tupate nini? Watoto. Mimi najivunia kukuwa bibi wa pili, bibi wa tatu, unaona? So walijaribu sana kusuppress hii, na kuna kesi where huyu mwanamume alifanya ndoa na walioana katika desturi za just native customary marriage, na huyu mwanaume akakuwa converted to Christianity. Vile walipeleka hii kesi yao kotini wakijaribu ku-identify if this woman is really the wife, the judge alisema mlifanya harusi kulingana na mila na desturi zenyu. So this is not, as much as you are a Christian, kama ni Mkristo, hatuta recognize huyu bibi yako. She's not a wife. She's just merely you're just merely cohabiting together, unaona? So the wakoloni walijaribu kusuppress kitu sana, kajaribu kutufinyilia sana, and they really succeeded because as you can see right now, most of us are really monogamous. We cannot condone polygamy. Kisikia bwana wako ako na bibi mwingine umekasirika tu, amepata kwa nini? Unaona? Vitu kama hizo. So in the 1969 constitution, after such tupate uhuru wetu, akajaribu ku bring back now the family to the cultural aspect. Akajaribu sasa kuleta familia back to where we were. But unajua sasa we were now viewed under the international globe. Sasa tunaangaliwa na countries zingine mnafanya nini, and some of the things that we used to do, for example FGM, unaona, kukeketaje wasichana, it was a good thing. Sisi tulikuwa tunaivu kama ni kitu nzuri juu it was like a way of preserving virginity for women. For girls, don't go and engage in various things, you know, polygamy, that was such an amazing thing. Nikikuja kwa mambo ya ugawaji wa kugawa shamba after, you know, death of a spouse or something, unajua sasa kitambo it was a man, kila shamba ni ya mwanaume, shamba si ya msichana. Bwana akikufa shamba inaenda kwa nani? Kwa mtoto wa kiume, si mtoto wa msichana, unaona? So such things were really gender biased, especially towards women. Wanawake hawakuwa na any authority. And this is why the 2010 constitution ilileta sasa the aspect of family, the aspect of gender equity. Mwanamke anaweza own shamba, unaona? Mwanamke hata bwanake after akufe, she has the authority to own land. The female child has the authority to own land, unaona? So si kama kitambo ati mwanamke o sijui wanaume sijui nini. Saini, if my husband dies, for example, bwanangu afe, I can inherit the land, I can acquire the land. Tukiachana pia neza acquire the property that we got together. Si kama kitambo ati tumeenda tukanunua shamba na baadaye nini shamba ni ya mwanaume. Unaona, if we buy a land together, I am entitled as the wife kufanya nini? Kupata a piece of that land. Unaona? So this is why the 2010 constitution included the family, and it is recognized as the natural and fundamental unit of the society. It's very, very important. Society haiwezi kuwa bila familia, and we as the African view the family as a very, very important thing. What I can say that we have progressed really is to make a familia at the forefront. You can now go and fight for your family rights. And another important aspect is equality. And I think our previous speaker today, alipeana the example of the case of MW versus A Nakuru. Pali alisema domestic labor is viewed as monetary contribution towards property. For example, mimi nimeoa, nimepata bwana, tukanunua shamba, si ndio? Sasa yeye amenunua shamba, lakini mimi ndo nimesaidia kukuza hii shamba. Nimebuild properties, nimenunua sijui simiti ya kujenga nyumba, nimenunua tiles. Sasa tukiachana, si ati juni yeye alinunua shamba na nienda ndo kuna manyumba under his name, I am still entitled to have a say in the matrimonial property. You get me? This is matrimonial property that you're talking about. Yani nyumba na shamba, kila kitu nye tumeacquire pamoja. Unaona? And then there is also equality at the time of marriage, during marriage, and at the time of dissolution. Unaona? Tukikuwa pamoja, si ati juu tuko pamoja utani respect, lakini tukiachana hatutakuwa respectful towards each other, okay? We have equality. You have the right to say that I have a say in this piece of land that we acquired together. Niko na the right to say that this land, mimi ndo nimekuza, mimi ndo nimenunua tiles, mimi ndo nimeleta plumber, nimeleta electrician. You have a right to go and say that I did this, and you have to prove that ulifanya hivyo. So kuna kitu ingine sasa, especially among the Gen Zs, inaitwa come we stay. I don't want to marry you. I don't want to stay with you. Like, put a ring on your finger or something like that. Kutembea down the aisle. Tuende tukalipe mahari. No, we want to come and stay together. Especially among couples in campuses, you know. Come we stay, kuja tukae pamoja tuone if you are compatible. And these relationships actually stay for a long time. Unapata umekaa na huyo mtu for like 25 years, mmepata watoto, mmefanya kila kitu pamoja, you've even acquired land together. Lakini hamjafanya nini? Have not registered your marriage, you've not registered your union, hata hamjaona wazazi. Nyinyi mnajua tu tumekaa pamoja, unaona? So such unions are an exception. Si ati ni marriage. Usiende kusema ati hiyo ni ndoa. No, that's an exception to marriage, and it's actually considered time ya kugawa matrimonial property or during divorce. Naona? So this union, nitakupea kesi. It's Mary Nyambura versus Paul Ogari. Hawa watu walikuwa wamekaa pamoja for 25 years. Na wakapata hadi watoto. Na wakakwaya property pamoja, rental units pamoja. But the man, after wachane, the man did not get the property because the property was under the wife's name. So he was like, no, I really need to have a say. Mimi ni mwanaume, mbona unaninyima shamba, unaona? Kitu kama hiyo. So koti ilisema there is this recent trend of come we stay couples, interdependent unions. We really need to acknowledge that it's a rising trend, and I think that's why we've lagged behind, because we only consider it during matrimonial property division, unaona? But we need to consider them as like a rightful union or something like that. And usisahau, ukifanya come we stay, you know, tateseka, bwanako akikufa mama kiachana. So I really recommend that you register your marriage or have a customary marriage. Just my say. That's just my say. Another thing that is really rising right now is the rise of the LGBTQ community and the intersex persons. The LGBTQ people are people who, you know, niko attracted to the person of the same gender. Mi nimekuwa attracted kwa msichana, mvulana amekuwa attracted kwa mvulana. Unaona? I think Kenya has made quite a significant step to recognize these people. For example, in the EG case, the LGBTQ people walipewa authority to form an association. No. But why are we preventing them from having marriage? Why are we preventing them from, you know, coming together, having a union? Najua nitapigwa sana, lakini LGBTQ is quite a thing, and I think maybe Kenya should make a step towards that. But unajua story na kwanga, that's an African thing, you know. Hiyo si Afrika kabisa. So I think we should recognize that. We should take a step towards that, and especially the intersex people, watu wako na the same organs, like we have two sex organs. We have recognized these people as the third gender. Tumejua this is another gender in Kenya. Why are we not recognizing them to form marriage, to have a union with a person? Why we tunaenda hospitali unamwambia utakuwa mwanaume, and then this person grows up and then maybe starts exhibiting girl characters, ameanza kuvaa kama msichana, unaona? Wewe kama mzazi unaanza kujiuliza ni shida na mtoto wangu. Anakuleta msichana mwingine, anakuleta mvulana mwingine because maybe yeye are attracted to men. So we need to acknowledge that we are in a global trend, and long discussion about LGBTQ because I firmly believe it's African. But, you know, we really need to recognize these people, and I think I'll put my discussion to rest there. Thank you very much.
Yeah, I was muted, sorry. Yeah, thank you very much for that discussion and for raising important issues that I truly believe are issues that Kenyans need to engage in. So without wasting any time, I would like to invite Daisy to speak about article, hold on, Daisy. No, Daisy, you are welcome.
Thank you, Dr. Mwanza. Just to pick up from where you left, I'm speaking on Article 46.
46, yes.
That is on consumer rights, yes. I don't know if I'll be able to speak as eloquently as my co-panelists in Swahili. Yeah, but generally Article 46 is one of what I consider the most transformative articles within the Bill of Rights. And it speaks to the vital aspects of our lives, the food we eat, the medicine that we go purchase, the loans that we borrow, any digital service that we need to access. And so it's just more than legal provision. It's something that guarantees all the aspects of dignity, the safety that we would need as human beings or citizens in Kenya, and fairness in the marketplace as well. Just to give a context of the previous, how it was before 2010, we didn't have a specific law that gave or enforced this right to have your consumer rights being protected within the law. And you would find that we would know of a neighbor, yule ambaye amesomea public health, anakuja mmekata nyama, anakuja kuraba stamp, ama unaenda kwa butchery unatafuta ile yenye imewekwa stamp yenye imeandikwa public health certified. Those were just the idea of what we had on consumer rights. Ama ukienda kutafuta kitu yoyote ukinunua pale supermarket, unatafuta ile imewekwa hiyo mark ya KEBS kuonyesha that iko in the standard value. But coming to the years after 2010, we found a place that this right sits well. And just to give a context on what Article 46 provides, it entails 4 fundamental consumer rights. One is accessing goods and services of reasonable quality, having the right information which is necessary for you to have the full benefit or get the full benefit from the goods or services that you are trying to procure. The third one is having the right to protection of your health, safety, and economic interests. And lastly, the right to compensation for loss or injury arising from defects. What I would say is that the framing of Article 46 in its own right is deliberate and significant because it covers all those aspects that I mentioned in my opening statement. And one thing for sure, you will see that it applies to both the state actors and non-state actors. And just to give context of how these 4 rights or 4 elements come in, the first example is what happened in 2018. We had the Competition Authority of Kenya fining Bidco Africa when they had issues with labeling their products. Ama leo ukienda supermarket unaenda kununua coriander imekuwa packaged tayari, ukienda kufungua iko nusu. What do we do? These are just the aspects which this right governs. Ama ile siku umechukua loan ya Tala, unapata neighbor wako amepigiwa simu anaambiwa, enda ututafutie Daisy, mwambie arudishe. Kuna ile 5,000 alikuwa ameomba mwezi uliopita, inafaa kwa imelipwa tarehe ya leo. Ama message inatumwa. The other example is in 2019 when we had issues of political messages being sent to our phones, where unaamka asubuhi unapata MCA wako amekutumia message ya campaign. Those are just the examples of how these rights are being protected in the current era. And we've seen how courts have enforced this right, making it self-executing in itself, such that we don't need to have a myriad of legislation for it to be said that it is being implemented. We've seen the Central Bank of Kenya introducing regulations to govern how digital services are being provided, how are the rates being capped, so that kesho asubuhi hatuwezi amka tunapata KCB imeongeza interest ya kuomba loan anyhow venye inajisikia, ama ikiona the economic interest zinaelekea kwa nzuri, ama watu wengi wameanza kupenda kwenda Equity wana reduce yao sana, vitu kama hizo. Hiyo tu ni the general aspect of this right. And I think kusema how 2010 to 2025 has been, this is one of the rights that is every day self-executing. You do it, you see it, and you live it. That is just the general context of it. And kupeana pia mifano ni kuwa Kenya imeendelea kuweka laws. Kuna zile Competition Act ambayo inaanza kuintroduce Competition Authority of Kenya. Na Competition Authority of Kenya iko na uwezo wa kudeal na practices zile zenye ni unfair ama misleading, ama upate leo unaenda betting inaonyeshwa online ni different from how it is in the real actual place where you are having your betting sites, ama a particular company ina misuse ile dominance ambayo iko nayo, ama advertisement yenye inapeanwa na watu wa Bidco, ama ile siku na order kitu kutoka Jumia unapata venye unasemanga what I ordered versus what I get inakuwa tofauti. So hizo ni zile examples tu ya vitu zenye tunaendelea engage nayo kila siku, na hii article imekuja kuwa kama a protector. The one thing that guides everything, even if today I went to Kabarak University for my law degree and I didn't get, that is just an example. I wonder if that would be the same if we went to other places. The other thing that we saw most recently is on Kenya Information and Communication Act, the service quality that is being gotten from the tariffs that we see, the oversight of these tariffs, where one day you get some of the minutes, or you see the airtime that is given to this particular service product that is shown. Those are just the examples of things that this article governs. And most importantly, what I saw is on health, and there was a research that was being done previously on comparing how countries are dealing with introduction of products into their market. And I went to, when you checked the website that Pharmacy and Poisons Board has, it will show the requirements that are needed. If I'm introducing today a product, like I need to have an energizer introduced to the market, there are some requirements. Si kama ile siku ambayo before 2010 ungepata a whole village imekuwa swept away by taking alcohol that was illegally brewed, such things, you know. Ama kama mtu anataka vegan product na haijawekwa ionyeshe that ni non-vegan, how do you deal with such instances? So that is just the general context of this article, and I hope it has laid a good foundation on the progress of this discussion. Thank you, Dr. Mwanza.
Okay, thank you so much, Daisy, for your presentation. I don't know why I appear on two streams, but that's okay. Maybe I'll correct it once I'm done. So I'll try to speak a few words in Swahili, but nikikwama, then I will switch back. Asante sana to Njogu, Shelin, Teresia, and Daisy. What you have said really shows us that the Constitution has been, in my opinion, transformative. Kwa mfano, Njogu ametuonyesha kuwa the Constitution now has this advanced framework, both legislative as inspired legislative na institution za kutatua mambo na ya kuhakikisha kwamba mazingira yetu ni masafi. Naye Shelin ametuonyesha kuwa the Constitution addressed issues of culture. Kitambo, wakati wa ukoloni, our culture was considered to be backward na haikuwa imepewa ile protection ya constitution, lakini sasa tunaweza jivunia constitution ambayo imetuambia kwamba each one of us has a right to practice their own culture. Alafu Teresia ametuonyesha kuwa kwamba umetuelimisha sana kuhusu vile wakati wa ukoloni our own structures of family zingine ziliharibiwa, lakini sasa tuko na katiba ambayo inasema that we have a right or ina protect family as the fundamental unit of society. Lakini nina swali kwa kila moja na ningetaka kwa kila moja atumie maybe 2 minutes kuaddress swali ndio tufungue kwa maswali ya wale ambao are in attendance. And swali langu ni hili. So we can say that the constitution is transformative, first because it has addressed some of the issues as you have all explained to us, kwamba vile mmetuelimisha. But a constitution is also transformative, I believe, if it is able to withstand or to address changamoto mpya. Not just addressing what has been, but being able to withstand what wasomi wanasema challenges ama perturbations. Na moja yao, and this goes to Njogu, the first question goes to Njogu, ni the example you gave about nuclear waste. Hiyo ni changamoto that is both local, ya kwamba ni shida ambayo inahisiwa na wale wanaishi mahali the nuclear waste was dumped. Lakini ni shida pia of a transboundary nature kwa sababu hiyo nuclear waste ilitoka nchi zingine, haikutoka Kenya. So do you think, what would you say or what recommendation would you give to ensure that the constitution can deal with those, extremely complex types of environmental problems that have origin elsewhere and the negative effects are felt in our country? Alafu kwa Shelin, ulituonyesha kuwa now our language and culture is protected, but I feel like bado the conversation about what aspects of our culture should be protected and what aspects of our culture should be considered bad is still ongoing. Ungesema, what should we do to ensure that the constitution actually serves to protect culture that is beneficial? Kwa sababu, especially because kuna watu ambao wanaweza angalia one cultural practice waseme hii ni nzuri kwangu, lakini watu wengine wanaiona wanasema hii sio nzuri kwangu, we should eliminate it. How do we ensure that the constitution speaks to this sometimes opposing views of what counts as beneficial culture? And I think I will extend the same question to Teresia, because you spoke about family and you raised mambo ambayo yanaleta changamoto sana in our country, especially because statistics zinasema 80% of Kenyans are Christian. So when you try to have a conversation about how the LGBTQ community is lazima wapewe haki zao, then you are likely to get pushback, and I'm sure you said yourself that you anticipate some pushback. How can the constitution address changamoto kama hiyo ambao you know very well that the courts may say one thing, but things in the societies may really be against what the constitution is trying to protect? Alafu the final thing ni Daisy, na swali la kwako Daisy is actually coming from the examples that you gave of the persistent problems that consumers must face. What needs to be done to ensure that the constitution can address these issues? Especially nchi yetu iko na watu wengi sana, young people who are turning now to the so-called loan sharks. Could you pick one of the issues that you raised and maybe think through ama utueleze zaidi what you think the constitution can do to address it? So ningeomba kila mtu achukue 2 minutes at most, alafu tutafungua the floor for Q&A. So we'll start with Njogu. Thank you. And I will barge in if you go for too long, sorry.
Okay, thank you, Dr. Rosemary, for your question. Okay, so Yeah, I hinted at a scenario whereby nuclear waste was dumped into our country, and essentially that nuclear waste was imported, if I would say so. And I would base my answer by stating, first of all, that the Constitution sets principles which are to be followed by legislators and everyone dealing with environmental matters. And so, whatever we do ought to be on the basis of the principles set in the Constitution. And I would like to direct us to the Article 42 itself. Article 42A states clearly that we ought to have the environment protected for our generation and future generations. And by that, we ought to ensure that any action that we do caters for our generation and keeps in mind future generations. Additionally, I would like to add I'd like to answer by making reference to a tool. Yeah, I call it a tool, the environmental impact assessment tests that ought to be carried out before any project is done. So, this means before any project that ought to or maybe has the potential to damage the environment is carried out, we ought to have an environmental impact assessment to ensure that the project that's supposed to be done or that's going to be done, the potential project, shall not damage the environment and, the environment in a way that affects us and the future generations. So by doing that, we'll ensure that maybe in a scenario which I don't really foresee any other scenario where we import nuclear waste, we should ensure that we do an environmental impact assessment before carrying on with the project or proposed projects. And this cuts across each and every project that anyone does, including the building and manufacturing of residential areas, the building of bridges and everything else. You're supposed to do an environmental impact assessment before that. And I think that answers your question, unless, it's unsatisfactory.
Thank you. Yes, it does. Thank you. Can we have Shalene answer if the Constitution will be able to address this outstanding, or it can address these outstanding issues?
The Constitution can be able to address the issue of what is, because different communities have different practices. Utapata Wakikuyu wanasema hivi ndio si tunaamini, ama Waluya hivi ndio tunafanya. Kwa hivyo ukiangalia Article 44.3 kwa Constitution inasema protect, huwezi lazimisha mtu kufanya kitu yenye itasababisha imuumize, for instance. Alafu pia the government has come up with a law, an act which lists the different traditional Protection of Traditional Knowledge and Cultural Innovations Act. So inaonyesha vitu tofauti ambazo kwa jamii, for instance, zikubalike. Kwa mfano kuna inventions za community fulani ziprotectiwe. Alafu pia kuna article kwa Constitution inasema ni repugnancy clause. Customary law, for instance, haitakubaliwa kama haitaleta haki na si kitu ya morals tunahitaji kwa Kiswahili. Kitu hivyo venyewe vile amesema. If it's repugnant to justice and morality. So kama ita affect watu wengine, italeta kitu ya haki ama sawa, hatutakubali. So huwezi sema ati sababu Waluya wanafanyanga hivyo, hata nyie msifanye hivyo, kuna vile wanalinda tu. So huwezi lazimisha mtu kufanya kitu ambayo hapendi. Hata kama nyiko sawa, kwa wengine kama wanaona si sawa, huwezi mlazimisha.
Asante.
In answering your question, I think I'll just take you back to the CKRC report. When they're drafting the Constitution, one thing that was said, especially by the people, was that hatutaki ndoa za watu wa jinsia moja, we don't want homosexual unions. And that is quite alarming because, I mean, we used to do that, so why are we refusing it? I think the Constitution cannot address the LGBTQ community because if you read the Article 45, it says, 45.2, every adult has the right to marry a person of the opposite sex. I'll emphasize on opposite sex. So LGBTQ people don't really have quite the constitutional stand to say that they have the right to marry, but I will advocate for the intersex people because they have been recognized as a third gender. So they should form unions, they should form marital unions. And I think the problem still lies with the people, with the common people, because we have this mindset that there should be only two genders. You're either a man or a woman. You choose. So if you're born an intersex, you have to choose. Do you want to become a man? Do you want to become a woman? Why can't I have both? Why can't I have a person whom is going to marry me because I'm an intersex person? The LGBTQ community is, the LGBTQ issue is really wide. I'll face a lot of backlash, but as I said, that we need to embrace such growing trends like the way South Africa did. We need to embrace it. We should not beat them up. Unaona kama Uganda ukienda, kama we ni gay wewe jo ukienda Uganda wewe, unajua umeisha. They have an Anti-Homosexuality Act 2023. So if you're found that you're homosexual, you're going to jail. Wewe umeisha. So it cannot really address that, and I think that's where we're lagging behind. I don't think that's really transformative because we're not embracing the growing trends of it, and I think that's a gap in the Constitution in addressing LGBTQ people. Thank you.
Santi. So let's have Daisy as the last person. Then after Daisy, we'll open the floor.
Thank you, Dr. Amanza. I think as I began my opening remarks, I said that the reading of Article 46 and the writing of it was deliberate and significant. And I think that makes it quite adaptable even to modern challenges, because to give an example of issues like digital finance and surveillance, the cases that we've seen KATIBA Institute taking to court and how Communications Authority of Kenya has responded, I think that is the beauty of how it was written and how it is going to assist us even in the future challenges that we may encounter. We've seen how the government itself has come up with practical programs. We saw public awareness campaigns that COFEC has introduced with the CAK. We've seen how the FSD has the outcome index that they do yearly that shows how our consumers, are they satisfied with the services that they get. And we've seen even the practical examples like the immigration services that have come out these days. I remember previously when I applied for my passport, it took me like a whole month, but these days you can get it in 3 days. Mm-hmm. You see, it's just a question of how efficient and how willing are these redress mechanisms going to come up and deal with these challenges that are coming. And so I think it's just about ensuring that the programs that are introduced are more practical and being adaptable in itself. That is my short response to that.
Okay, thank you so much. So now, thank you for metuelimisha sana, the panelists, but we are not done with you. You will get a few questions. We have one question already directed to Charlene. I shall read that to you, Charlene. Then I will ask the audience to also raise their hands, and I don't know who is helping me from that end. I suggest that we take maybe up to 3 questions and then allow the panelists to answer. So swali la kwanza ni kwa Madam Shelin, na hili swali limetoka kwa Kipkore Kipyatich. Kipkore Kipyatich ameuliza, according to your own perspective, has Kenya done enough to protect minority languages and cultures under Article 44? Pengine 2 other questions should accompany hili swali la Kipkore.
Oh, thank you very much. I think I'm very...
Sorry? I can't hear you, but just carry on.
much. I don't like this thing, eh? So, as I said, I'm Cosmas Mutua, Director Hope in Life based in Nakuru. And I like this discussion about the family because, first of all, I'm a family person. I'm a father of four children, 3 boys and one beautiful girl and 3 handsome boys as the father and the mother. So thank you very much. And I like this topic. So my take is on the family. Not everything African was bad, even traditionally. There are those positive cultures and the rest, like the issue of our family values. So I agree with Article 45 on several issues about protecting the family values. But remember that some of those things you share about the emerging issues and trends of the family, that the LGBTIQ and the rest, those are Western cultures. So why should we borrow what is Western? Si hata wachukue yetu wachukue FGM na the rest the bad ones. So I am a protector of family values because they are the natural law. Because I deal with reproductive health. And I've seen adults using diapers because of not respecting nature. So kwa hiyo kama ni mzuri, mbona wanatumia diaper? An adult anatumia diaper because the system is spoiled. The boot and the bonnet is spoiled. In other words. So the other thing is about the equality and equity. I'm an advocate for equity more. Because equality means, maybe all of you, like, I have some spectacles. Napea kila mtu mwingine ako naye already. But equity is try to give mwenye hana unampatia chenye anahitaji. Maybe she needs something apart from the spectacles and the rest. So that is the other thing. So we have those beneficial cultures and some that are not beneficial. And also I like the issue of the best interest of the children. We have developed a culture whereby some people are getting into union for material gain, which is quite unfortunate. Na siku hizi hata itu come we stay is come we try. So come we try does not work anymore. Na hii mambo ya polygamy, I know it's something that it was in the African culture but not the best because siku hizi uchumi imekuwa ngumu mpaka tunaomba ningepewa mrembo tu nusu ule wangu wakati tu nipewe quota ningechukua hiyo. Then there's also the consumer rights. I like it. Somebody share about the consumer rights in terms of easy companies, unakuta the betting companies and the rest. And also the issue of the online marketing. Sangine unabai kitu unakuwa so discouraged. I've bought 2 shoes twice through Jumia, to be precise. Maziche yenye uliona imeandikwa huko kwa online, what you get is totally different. Very poor and bad quality. So I think we need to be protected as consumers. And also kwa wale watu chapa kamunywes kama mimi, sindio? Alcohol pia. Kumekuwa na lot of counterfeit. Sio mimi wewe kama wewe, sindio? Kumekuwa na lot of counterfeit and we need to protect our consumers and all that. So thank you very much. I was just introducing myself. Let me start my long speech. Thank you very much. Thank you.
Okay. My name is Caro, and actually the discussion is very interesting as far as family, culture, and language is concerned. So we are talking of constitutional transformation in Kenya, that is transformative. And my question goes to Article 44, culture and language. And in your own opinion, tumetoka mbali, you've given us the history, vile kulikuwa kunafanyika. Na ndio sababu vipengele hivi vikawekwa katika hiyo katiba ili kuzuia mambo ya culture na kitamaduni ambazo ni harmful. We have witnessed as community members, we still have those cultural practices that are very harmful, that are negative, especially the one that you've really mentioned about the FGM. In your opinion, in your own opinion, as our current learned friends, if you are given an opportunity to redraft that Article 44, what will you add? What will you add in that article ile ambayo itaweza utekelezaji katika ground? Because actually we have very good articles in the constitution, but the implementation haijafanyika kwa ground. We are doing something on fighting FGM and all those cultural practices that are harmful, but still hatujafika pale. And here we are talking about transformative constitution. What will you do as a learned friend if given an opportunity to redraft, to rewrite that article? What strategy will you use ili iweze kutusaidia sisi as community members and people working with civil society kuweza kuhakikisha ya kwamba tuna terminate hizo harmful practices that are still ongoing in our communities. Thank you so much.
Thank you. I think we should take those 3 questions and then those questions first. I would ask the panelists to try their best to answer and to be brief. Then after that, we'll take a few more questions.
So the
And
first
I should say thank you to those who have raised questions and for engaging with the panelists.
So whether Kenya, the first one was whether the Kenya as a government has done enough to protect the indigenous communities in Kenya. I can say there's a way they've put provisions in the constitution where they say marginalized groups will be protected, and then they've even gone ahead to specify who are these people who are marginalized. Kama for instance, our easy communities zenye, kama hiyo kesi yenye niliwaambia ya Ogiek, yeah? Unaona kama hiyo kesi pronouncement ilishapeana na koti, government recognize hawa Ogiek kama indigenous community na warudishe shamba ama walipe pesa, but tunaona kuimplement imekuwa slow. Decision inapeanwa but implementation pia because of resources, na tulisema ni progressive, inafanyika kulingana na uwezo ya serikali. Labda serikali haina uwezo kwa vitu zingine, so inakuwa slow ensure that these people are actually protected, but serikali ina recognize kuna communities zinafaa zikuwe protected already, sababu kuna vitu ni communities kama uta protect watakuwa extinct ama hiyo language pia itapotea. So kuna mikakati kwa ground, kuna policies zimewekwa kuensure hizi communities zinakuwa protected. Na yenye umeniuliza kuhusu kwa opinion yangu kwa ground, how would I help community members? I believe there are measures. Kama hiyo ya FGM, kuna wakati walikuwa na arrest hawa mama ambao walikuwa wanafanyisha hizi forced. Alafu kuna time pia hii ya vijana for instance, kitambo walikuwa wanafanya tu ile ya kienyeji, but watu wamefundishwa unaweza enda hospitali ama wana provide tools za kutumia for instance zenye hazitasababisha magonjwa ama shida ya kiafya. But nadhani kuna policy, shida tu ni maybe pesa na resources za kuimplement, because ukiangalia kwa kila county kuna measures zimewekwa. Shida ni resources. Sasa hiyo tunaomba Mungu atupe resources, labda pesa ndio haiko kwa wingi na tuna face vitu kama corruption, so inakuwa shida. So polepole tu tutafika, lakini ni jani tumeambiwa haiwezi kuwa ni kupigana. Unaenda koti, unaona kama hiyo article 22 inasema ukifeel ni kama rights zako ziko violated, unaweza enda as a group, mnasema tunaona hapa kitu haijaenda sawa, yeah. So tunaomba wacha tuone vile kutaendelea, maybe miaka ingine 5 labda tutakuwa na resources ama policies zitakuwa, hizo structures zitakuwa zimewekwa kwa ground.
Thank you very much. I'm going to respond to Cosmas Mutua's question at Amingia. Thank you very much. I appreciate your comments about beneficial cultures and all that. You know, I get you. Totally good culture. You will really fight me against this, but LGBTQ is not an African. And I have various examples. Patana you may attend, nikuonyeshe hizi examples. Nana. Lunch hour. Very heated discussion. But I truly don't believe they are an African. I really don't believe, kulingana na the scholarly arguments that I've read and the various evidence that I have found. But as I say, you know, we are African, conform to African values. If you don't want to participate in the LGBTQ discussion, please don't. Don't engage in such things. We are Christians. This is a Christian institution, and I am not advocating for that. So please, yeah. So about equality and equity, I'm going to take you to a case, JOO versus MBO, the fact that you're in a marriage does not confer you, does not automatically confer you ownership to property. Because this will lead to now this whole idea that I'm just in a marriage to what? To gain. Niko kwa ndoa kufanya nini? Kupata tu mali. You know, with the whole 50-50 division of matrimonial property. And I'm really, really liking this example. Thank you very much for bringing me towards this. Because most of the things, kwanza, you know, baddies, unataka a man who can provide, a man who has cars, a man who has what, you know. But wewe unaleta nini? Wewe hata una shamba. And then after you get divorced, you just want to say that 50-50, I contributed. What did you do? As much as we have said that even domestic labor, care for the family can be recognized as contribution towards gaining this, towards division of matrimonial property. But really, can we just be in a relationship just because you want money? You're with this rich 89-year-old man just to what? To get money, to get property? Really? We don't advocate for that. And when you go to court, that's a whole contention. So I advocate that women bring something to the table, you know? Bring something, just take care of that place, you know, and actually prove that you have done that. Just don't go with the blind mindset that utapata 50-50 after that, you know. And now the whole discussion in Kenya, and I think a certain scholar in Kabarak did it, I've forgotten her name. She brings now the whole contention of sasa inafaa ikuwe 50-50, ama ni 70-30, ama ni 60-40, tutafanya aje? Should we now say that we set 15% of this division, of this property to 50-50, then the rest to 30-40, 60-40, 20-80, who knows? So it's a whole discussion, and thank you very much for bringing me towards that. So I think I've answered your questions. Okay.
I think those are the questions that we had. We'll now take more questions on the floor. I believe we have 3 hands up, and then we'll have one more from online.
Yes, my name is Mwangi Moraya Wanyambugi from Nakuru Human Rights Defenders Network. Na kuna hicho kipengele cha 44 kuhusu lugha na utamaduni. Na lugha tunajua ni chombo muhimu katika kumkomboa mtu, ndipo sababu naona Marekani ilipojikomboa kutoka kwa Uingereza walikuja na Kiingereza chao ambacho ni cha Kimarekani. Tukiangalia katika hicho kipengele, nadhani mkiwa kama wataalamu wa sheria mtaweza kunielezea ni nini, ni kasoro ipi ambayo katiba yetu iko nayo, kwa sababu hata wazungu walikuwa na juhudi za kukitambua Kiswahili kuliko serikali za Kiafrika ambazo tuko nazo, kwa sababu tunaona mwaka wa 1923 kulikuwa na jopo lilikuwa linashughulikia Kiswahili. 1960s Ominde Commission ilikuwa pia imependekeza kuhusu kuendeleza kwa lugha ya Kiswahili, na tukijilinganisha na lugha na taifa la Tanzania, wao tu walipojipatia uhuru walikuwa na tume na pia wana taasisi ya lugha ya Kiswahili. Tanzania saa hizi inawapeleka walimu wa Kiswahili kote duniani. Hapa Kenya bado Kiswahili, kwa mfano kama unaongea Kiswahili kibaya unaonekana kama umesoma. Ukiongea Kiingereza hapo, ukienda mikutano mingi kama umekosea unaambiwa uimbe na lugha yenu ya kinyumbani. So pia ningeweza kuelezea wale wazungumzaji ambao wako pale, kuna policy ambayo inaitwa language policy ambayo it is in draft form ambayo ipo. Ningependa muweze kuiangalia muone kama inaweza kuambatana na mazungumzo yale. Kwa hivyo article 44 tied with article 7 ambayo inatambua Kiswahili kama lugha rasmi na lugha ya kitaifa. Ningependa kujua ni kwa nini labda tumechukua miaka kama 60 tukiendelea kufedhehesha, kudhalalisha na kuaibisha lugha ya Kiswahili na kueneza lugha ya Kimombo. Mwisho kabisa, India ilipotua katika mwezi, ilisikiza vizuri sana wakionyesha hiyo kitu live. Walikuwa wanaendesha satellite yao kwa lugha ya Kihindi. China ilikuwa inaendesha satellite yao kwa mwezi na wameland penye Amerika haijawahi land kwa lugha ya Kichina. Kwa nini tumekubali kulemazwa na mawazo ya kikasumba kwamba unapoongea lugha za kigeni unaonekana kama umeendelea, unapoongea lugha za hapa nyumbani kwanza unapoziharibu na kuvunja sheria zake ndio unaonekana kama umeendelea. Lazima tujikomboe, na ni through Article 44 tied to Article 7.
Good afternoon. My name is Elodie Musumba. I'm a student at Kabarak. Hello. Okay. My name is Elodie Musumba, and my name is Elodie Musumba, and I'm a student at Kabarak. So my question is to Article 42. I'm George Njogu. So we've seen a lot of unauthorized dumping. Actually, most of us tunatambua Geoffrey Mosiria. He goes around trying to deal with unauthorized dumping. So unauthorized dumping is one of the challenges. So from your research, what are some of the other challenges you saw as a country we are facing in terms of the protecting the environment and trying to exercise Article 42? And also, what are some of the recommendations you'd give moving forward? Thank you.
Okay, I'm calling Smirigi, a Kabarak student, third year. And my question is, if culture is an inheritance, then can it be a prison? And if in Kenya, a child who is only 8 years can be held criminally liable, why don't we have an age limit where someone will choose a culture for themselves? We are just dealing with I can just bring an issue when culture is inconsistent with the constitution. But what is my case when culture is not inconsistent with the constitution, but it's not my priority? I'm basing my, I like to make the reference to 2017, Norway. It is an International Religious Freedom Report of 2017. And if in Norway, it's a religious one, but they say at 15, you can join or leave a religion. At the age of 7 years, parents have to take your views on the religion you are choosing before they make a decision. And at 12 years old, they need to prioritize your views. So why can't we have that in Kenya? Or do you think it's high time we bring that into the Kenyan context? Thank you.
Basi asante. Kwa jina langu ni Joseph Jesang kutoka community. Nimesikia kuhusu mambo ya sheria ambao pengine watu wengine wanataka kuharibu culture yetu kwa njia ambao kitamaduni ya Kiafrika inakataa. Sasa Biblia inataja vizuri kwamba ni mwanaume na mwanamke ndio wanawana. Lakini kusikia kuna watu wengine wanataka mwanaume kwa mwanaume, hiyo kwetu ni laana na haistahili. Jambo la pili, ningetaka kuwaambia vijana wetu ambao hawa ni wajukuu wangu kwamba tuangalie mambo ya katiba, isije tukaunda katiba ambao itakuja kuangamiza nyinyi pamoja na watoto wenu. Sisi ni wazee, tuko saa 11. Nyinyi bado mko saa 3. Chungeni sana kwa sababu hebu niambie kitu moja ambayo ilitokea siku moja. Kuna chief aliita, kuna wizi ilienea sehemu. Alafu chief akaita baraza akasema tumeona uwezi imezidi na ni vijana. Kwa hivyo tuweke sheria leo, kijana ambao atapatikana akifa tutopoe macho yote. Basi wakakubaliana sawa, tuendelee hivyo. So ikaenda muda kidogo ikapatikana mwizi. Kaambiwa chief tumepata. Akasema leteni kama vile tulikubaliana. Ikaletwa kupika mbele yake ni mtoto yake. Sasa kijana akiangalia mzee anatoa machozi. Papa akiangalia kijana yake anatoa machozi. Papa akasema kwa sababu tulipitisha na hatutaki kukosea sheria, topoa chicho ya huyu kijana mmoja, mtopoe yangu mmoja. Ndio tutimize vile tuliongea. Sasa watu wakasema tukitopoa chicho ya chief tutabaki kweli kwa DC. Wakasema bwana chief, hiyo sheria tutupilie mbali, wewe upaki salama na kijana wako apaki salama. So kwa hivyo mtuchunge, mnapotunga sheria mchunge, mtusitunge ambayo itatuumiza baadaye. Asanteni sana.
Hamjambo. Kwa majina naitwa Athman Ngala. Nashukuru dadangu alipojirekebisha kuhusu utambuzi wa wenye kuoana wa jinsia moja. Kusema ukweli, mimi ni Muislamu na nimejitambulisha ni Mkristo, na kuna Wakristo wengi sana hapa. Jambo hili hata kwa Mungu limelaaniwa sana, kwa sababu ukiangalia Biblia linakwambia go and multiply, ndio? Pia kwa Waislamu ni hivyo hivyo, nendeni mzaane. Je, katika jinsia moja kuna kizazi kweli? Hakuna kizazi. Na isitoshe, yule mwenzangu alivyozungumza, angalia katika hiyo athari ya jinsia moja, wamefikia kununua nini? Diapers. Je, kuna mtu yoyote ambaye yuko hapa angependa kupitia situation kama hiyo? Kwa mfano wewe, mtoto wako awe katika hiyo situation, utakuwa tayari kugharamia hizo diapers? Kwa hivyo tusijiangamize kama alivyosema mzee. Ndio tuvithamini sana vya kwetu. Vya kwa watu ni vizuri, lakini vya kwetu ni bora. Tufahamu hilo. Na pointi ya pili ni katika lugha ya Kiswahili. Kiswahili ni lugha safi sana. Na hata ukiangalia wale watu wa fasihi, lugha ya Kiswahili ina thamani kubwa sana kushinda hata lugha ile ambayo tumebobea ya Kiingereza. Kwa sababu lugha ya Kiingereza imeombaomba kutoka kwa lugha zingine, lakini Kiswahili ijapokuwa kwa percentage tu ndogo sana, kwa asilimia ndogo, imechukua katika maneno mengine ya lugha kama ya Kiarabu na Mijikenda, lakini ni lugha asili iliyozaliwa hapa kwetu. Kiswahili sasa kinaenea Afrika na kumekuwa na mijadala especially huko South Africa, na sasa hii kinatambulika Afrika. Watu wanataka kuipropose ili iwe ndio lugha ambayo itatumika Afrika. South Africa wameanza tayari kuifunza katika mashule, na pia sisi tujiandae, kwa sababu ni Tanzania na Kenya ndio tuko perfect sana katika lugha ya Kiswahili. Kwa hivyo ni tujiandae, tujiimarishe ili tuweze kutoa mfano kwa wenzetu wa Afrika. Asanteni, yangu ni hayo tu.
So I think those were comments and lessons. So allow me to just end this session so that we can do the next one very quickly. I can see my panelists are here. Rosemary, if you can hear me, thank you so much for taking and leading us on. I'm sure Paul will want to engage further. Daisy, if you can hear me, asante sana. And a round of applause for those who are here on the floor. Yes. Exit stage and bow. So we can stretch a bit, those who are sitting, as we wait for the next one. Don't worry, you'll ask the first question on this one. This one starting now. Have a seat.
So thank you very much. We are getting into the next panel. Tunataka kuanza hiyo panel ya pili, na tutakuwa na watu wanne wakizungumza kuhusiana na vipengele namba 47, Article 47, Article 48, Article 49 and Article 50. So before you tuko na watatu na kuna mmoja ambaye atajiunga nasi through mtandao. Esther Somba, kindly confirm if you can hear us and if you can join us.
Yes, I can hear you.
Yeah, thank you very much. So that is Esther. She'll be looking at Article 49, which is on the rights of arrested persons. Haki za wale ambao wamekamatwa. Nadhani sisi wote tunaweza kuwa na maswali kuhusiana na hiyo. Tuko na Rebecca Muhindi ambaye atazungumzia Article 47. Rebecca, tafadhali just wave wa kuone. Tuko na Rugenge Christian ambaye atazungumzia Article 48, access to justice. Tuko na Rosasi Miriam ambaye atazungumzia Article 50, the right to a fair hearing. Na kwa sababu najua lunch iko tayari, nataka niwasihi tuchukue muda usiopungua dakika 45 kuhusiana na hii, na tutajigawa half, nusu. Kwa hivyo hawa watachukua muda usiozidi dakika 25 kutuambia tu kuhusu hizo article zote 4. Alafu huo muda mwingine tutawaachia nyinyi muweze kuuliza maswali na pia kuchangia. Kwa hivyo sitaki kuchukua muda mwingi, nataka kualika sasa Rebecca Muhindi aanze na kutuambia kuhusiana na Fair Administration Action. Na Rebecca, nataka kupatia dakika 5 peke yake. Kwa hivyo najua uko na mengi ya kusema, lakini muda wa dakika 5 tu kutuambia hicho kipengele kinazungumzia nini.
Asante sana Bwana Alubala. Kwa majina naitwa Rebecca Muhindi. I'll be talking to you about Article 47 on the right to a fair administrative action. So when we talk about an administrative action, it's basically an act, an omission or a decision made by a public body or even a private person who is exercising a duty that is deemed to be public. So Article 47 states that every person has the right to an administrative action that is lawful, reasonable and procedurally fair. And it goes further to say that any person who is likely to be adversely affected by an administrative action has the right to be given reasons for why that action was taken. What this means is that before any public body, we know when a common mwananchi interacts with public power, it's unlikely to be the president or a minister or a governor. How a common mwananchi interacts with public power is through maybe a customs manager, a tax officer, or a customs person. That is how we experience public power, and more often than not, these interactions with public officials are marked by maladministration, delays, and I'm sure sisi wote tushaenda kwa ofisi ya serikali, si ndio? We have all seen how utenda hapo hivyo wanakurudisha, uende tena urudi siku nyingine, wanakusumbua labda hata wanataka hongo. So that is what Article 47 was intended to remedy. I'll give you a brief history about the situation before the 2010 Constitution. We all know that the colonial powers concentrated all the powers to themselves, and Africans' right to a fair administrative action was violated. Colonial masters made decisions such as taxes and land decisions without involving the African. I doubt they even deemed us to be human beings. Decisions also such as slavery. the fact that Africans were treated in inhumane ways talks much about the state of public service in the colonial service. So when we gained independence, the African elites were supposed to administer this power in a way that favored Kenyans, but instead they focused so much on eradicating the colonial regime, forgetting to establish the legal framework for the public service. So what follows is that when they get into power and they wield so much power to themselves, they also begin to violate the rights of fellow Africans. And in that period, service delivery is more of a favor than a right, because the people who are in office are those people who are beholden to the incumbent presidency. So service delivery was a favor. You are not guaranteed of a right. The very first time this right, the public service was tried to be held accountable was in 1970, I believe, by President Jomo Kenyatta. He established the Ndegwa Commission, which was supposed to inquire into the state of the public service and make recommendations on the same. And so they reported of the outcry about delays and maladministration, and their recommendation was to establish the office of the ombudsperson. But as good as that idea was, it was never implemented. And so the process continues, the same habits just continue. And in 2007, this is the first time we see a body that has been appointed to check public power. This was the Public Standing Committee. It was established by President Mwai Kibaki, but through a Gazette notice. Now, looking at the structure of its establishment, it was a creature of the executive. So therefore, it lacked independence, and it was susceptible to external influence. So it did not do a good job in checking public power. When there were discussions about enacting this new constitution, the CKRC Commission notes that as they went around to collect views, they say that the public complained of not only of corruption, but also of maladministration and generally the lack of a caring approach. And so what they decided to do is to borrow from the South African Constitution, Section 33 of the South African Constitution, on the right to a fair administrative action. So the Article 47 that we have today is borrowed from the South African Constitution. And so now we have codified the right to a fair administrative action, and it's 15 years later. Maybe just to wind up, we still see the Constitution has also given remedies to people who are affected by administrative decisions. We have two processes. Number one, you can apply to the court for judicial review, and the whole process of going to a court, having an advocate, the court has procedures which sometimes has technicalities, and also the other option is there is the Commission on Administrative Justice that is supposed to listen to matters of complaints from public bodies. That's the other remedy. You can approach the Commission on Administrative Justice to file a complaint, which they will investigate and make a recommendation. Seeing that time is far much spent, I will yield the floor back to the moderator.
Thank you very much, Rebecca. Rebecca is a fourth-year student here. I think she's really taken us through that right. And she has identified two institutional frameworks. Either you can go to court, wakati unasikia unanyanyaswa na mhudumu wa serikali, unaweza enda mahakamani kupitia hiyo process ya judicial review, ama unaweza enda kwa ile kaji inaitwa Commission of Administrative Justice. Kwa hivyo tutataka kusikia kutoka kwenu kama hiyo commission inafanya kazi, kwa sababu nadhani sisi wote tumekuwa victims wa unyanyaswaji na wale wahudumu wa serikali. Kwa hivyo nitataka kusikia kutoka kwenyu kama mmetumia hizo processes na kama mmezitumia ni changamoto gani ambazo mmepitia. So thank you very much, Rebecca. I'm sure there'll be questions on that. So let's now give the opportunity to Christian to take us through Article 48. So Christian was doing this research with Anne Kariuki. Unfortunately, Anne Kariuki is not here. But Christian, najua una uwezo wa kusimamia watu wawili. Kwa hivyo,
represent both of us.
Thank you.
Yeah, so Rugenge Wanchiko Christian, Kabarak law student in third year, second semester. And I'll be taking you through Article 48, which is on access to justice. So under the Constitution, it provided that the state shall ensure access to justice for all persons, and if any fee is required, it must be reasonable and it should not barry people from getting justice. And when you try to listen to that, you can see these are critical, or I can say a paradigm shift from the previous constitution, which did not even have the same terminology, because initially there was only Section 77 and Section 83, which provide for fair hearings, fair trial, and rights like that. But this terminology of access to justice was not there initially. And I can say also, it's not only a way of saying access to justice is only through formal courts. It can also be accessed outside under this specific constitution. And another thing from my own interpretation also is the fact that these rights, compared to other rights under the Bill of Rights, it's for all persons, so from citizen to non-citizen, and that's why I find it quite interesting, because the Constitution is very careful while using the language. Let's say, for example, only Kenyans have the right to vote, but when it comes to accessing justice, it's all of us, whether you're from Kenya, from Uganda, from Europe. It's something which I really love about this article. So when I have to look at the historical background of access to justice in Kenya, before colonization, people used to have their own traditional mechanism through which they will create their own legal system. Let's say, for example, in the Kikuyu, they used to have something called Kiamaya Wazee, where in case you are aggrieved or you have a problem with your neighbor, there's a dispute over land or anything like marriage, succession, you will decide amongst the community and find a more amicable solution. And that was a way of getting access to justice before colonization. Then when the colonizer came, they introduced formal codes, which was based on the British common law. And the formal code was only for the white people, the colonial settler, and native could not access justice because they were considered subjects and not human beings, and they did not have their full legal personality. And after Kenya gained independence, I think there was a change, even though it wasn't something really big, because there was this quote I had here immediately after independence, pretending to act on behalf of the majority, the emergent black African elites simply took the place of the minority white race that ruled during the colonial epoch. So our leader used the law to gain wealth, to gain political power, to have more influence over us. And it was not easy to get access to justice if you don't belong to a certain political affiliation. An example I use here is in the 1992, the Somali community was selectively issued ID and citizenship in order to, in exchange to vote for President Moi. So like, they were supposed to be given citizenship without having any political affiliation, but it was more of a must. If you want to have and enjoy specific rights in Kenya, you have to belong to the majority and you don't have to be in the opposition. And now coming to the 2010 Constitution, I think there's a lot of progress we have made as a country. The mere fact of having access to justice in the Constitution, and these rights can be elaborated also with the enactment of the Legal Aid Act in 2016, which established a national legal aid, and it provides that the state should give an opportunity to marginalized community, people who don't have enough money, free legal services, which is something which really matters. And I think also, apart from that, another thing is the fact that There are also some other NGOs which play a big and huge role in the country also to ensure people easily get access to justice. But there's still some problem even with our national legal aid, because the commission, I can say it's not really independent, and I can come back to that if there's any question. And to finish, what I can say about access to justice in Kenya is the fact that it's an actual journey, as we have all been talking about, and it's something which I think all the articles have in common. It has evolved from community-based system to the colonial era, and currently, I'm sure this article is really progressive, and it requires a lot of critical thinking in order for people to have access, and it's more a matter of how people can use the law to claim their rights. Yeah, thank you.
Thank you very much, Christian. And Christian ametujulisha kuhusiana na upatikanaji wa haki ama access to justice. Ni masuala ambayo tutakuwa tunazungumzia tukiendelea, na tutataka kusikia kutoka kwenyu kama mnaona kama kuna utekelezaji wa hiyo article ama hicho kipengele ambacho kinazungumzia kuhusiana na upatikanaji wa haki. Kwa mfano, Christian, ningependa kusikia kutoka kwenu, kumekuwa na changamoto zozote kufikia mahakama? Kwa sababu kufikia mahakama kunaambatana na masuala ambayo Christian amekuwa akiongelea. Ukiangalia kile kipengele namba 22 kinazungumzia kuhusiana na kinapendekeza kwamba hata unaweza andikia hakimu barua kumuuliza kama umeona kuna unyanyasaji fulani ambao unataka mahakama izingatie. Kwa hivyo tunataka kusikia kutoka kwenu kama kumekuwa na uwezekano wa upatikanaji wa haki baada ya hicho kipengele kuwekwa kwenye katiba, kwa sababu Christian ametuambia hapo before 2010 hatukuwa na kipengele kama hicho kwenye ile katiba ambayo ilikuwa repealed. Tutasikia kutoka kwenu, lakini kabla ya hapo wacha tupatie Esther Somba muda wa dakika 5 atuzungumzie kuhusiana na article 49 ambayo inahusiana na rights of arrested persons. So Esther, kama unaweza tusikiza tafadhali, dakika 5. Haki za wale ambao wamekamatwa.
Sawa. Good afternoon. Naweza nisikia? Okay. So, what exactly are rights of arrested persons? These are rights that have been accorded to arrested people as per Article 49 of the Constitution. So one would ask, why would we have right to liberty and such stuff? Like why would we need to have a right that explicitly provides for the rights of arrested persons? Well, we would have to go back and look at the history of Kenya and how arrested persons have been treated. I'll start with the year 1887, when the East African Trading Company was basically introduced in Kenya, and this was actually the origin of policing. So the East African Trading Company was owned by the Brits, who are our colonizers. At that point, the colonizers would use mostly like the already established forms of leadership here in Kenya. They would use them to maintain law and order. But after that proved to be ineffective, they decided to handpick their allies. Then came the village head ordinance, then later the Native Authority Ordinance for 1912 and 1937. So after all that, because at that point, our colonizers, the Brits, they used to use the police mostly to just concentrate power. They used to use the police to further their own interests, yes, and the police got a bad reputation. So in 1920, they established the police force that was supposed to be appealing to both Africans and Europeans. But they only changed the uniform, the name, but they didn't change the conduct and the culture and the policing culture. The policing culture became worse. It became worse all the way up till when we gained independence, and I think the violations were heightened in the 1940s during the resistance. So then comes independence, and one would think that, okay, we're no longer being colonized, maybe the police would be better, we'd have like democratic governance, but that wasn't the case. The first regime maintained the system that was set by our colonizers, and they used the police now to consolidate power to the executive, mainly the office of the president. So they still retained colonial era laws like the Vagrancy Act, the Outlying District Laws, and whatnot. So one thing that will show how minimal the effort was during that period to provide for the rights of arrested people was that, in fact, at that point, in both the 1963 Constitution and the 1969 Constitution, there's actually no particular article that explicitly provides for the rights of arrested persons. What happened was the rights of arrested persons were under Section 16 of the then Constitution, and were actually under what's it called? They were actually under the rights. They were actually under the provisions of the right to liberty. So it was under the provisions of the right to liberty that a few sections were dedicated to arrested persons. Okay, so from there we moved to the second regime. In the second regime basically adopted the same regime as the first regime. The leadership was still, dictatorial and tyrannical, and the police was still being used to amass power and concentrate it to the executive. And this became worse, especially around 1980, 1982, when there was a failed coup. We became a one-party state, and there were just violations everywhere. People were arrested without being taken to trial, torture. So it was really bad. But towards the end of the second regime, we can see that there were a few changes and a few developments. The first one, some of those developments were they did away with the
Sorry,
Preservation
Esther.
of Public Security Act, the Vagrancy
Esther,
Act.
can you hear me?
Pardon?
Can you hear me?
Yeah.
So kindly summarize in
Yeah.
a minute so that we move. Sorry about that. And perhaps you could
okay.
pay more attention to the article as presently captured in the Constitution. Thank you.
Okay. So given the clearly the history that I've outlined, it shows how the many violations by the police, then comes the 2010 Constitution. And this time the 2010 Constitution explicitly provides for the rights of arrested persons. So these rights include the right to be informed of the charges or the reasons for you being arrested. And this has to be done in a language that you understand. You also have to be informed of the right to remain silent and the consequences of not remaining silent. Other than that, there is also now the right, the right to remain silent. Other than that, there's a right, you're protected from being compelled to make any confessions. This means that you can't be tortured, you can't be beaten, threatened, and should you be tortured, beaten, threatened, and coerced into making any confession that's self-incriminating, then whatever you said is inadmissible. You also have the right to be held separately from other persons who are serving sentences. These are convicted people. You also are supposed to be brought to court within 24 hours of having been arrested. But if the 24 hours end during a period when either it's not a court day or it's out of court hours, then you have to be taken to court. You have to be brought to court before the end of the next available 24 hours, where it's a court day or during court hours. If you've been arrested and within 24 hours you have not yet been you've not yet been charged with anything, then you have the right to be released. You also have the right to be released on bail or bond, on reasonable conditions. It should not be expensive and like exorbitant. Like it shouldn't be an exorbitant amount. It also shouldn't be like a low amount. Yeah. So you have the right to this bail and bond unless there are compelling reasons as to why you cannot be released, like if it's a threat to public security, or if it is a threat, like if you're going to interfere with witnesses. Yeah. So yeah, I think I'm done with the summary.
Thank you very much, Esther. So I'm sure mmesikia masuala ya bail and bond, mmesikia masuala ya 24 hours kufikishwa mahakamani. Tutataka kusikia from your experience, does it work? And if not, what is supposed to happen? Then finally, tutamsikiza Miriam Rosasi kituzungumzia kuhusu Article 50. So Miriam, again, you'll have 5 minutes. The Article 50 is on the right to a fair hearing. Karibu, Miriam.
Thank you so much, Mr. Alubala. Good afternoon, everyone. My name again is Miriam Rosasi. I am a fourth-year law student here at Kabarak University. And we have heard about access to justice, rights of arrested persons, fair administrative action, and now the major question here when we're discussing fair hearing is it enough to be given a platform to access justice? Is that enough? Or it has to be in a way that you get to exercise your rights. And fair hearing is a really important aspect. It's a fundamental procedural right that enables us to exercise the substantive rights of our 2010 Constitution. And I think for me, this is a very fundamental right, because then if your rights are violated, you're taken to court and you do not get to the procedures, the fair hearing procedures are not followed, then there would be no essence, there would be no like a substantive remedy to your rights. So we have all along been having this aspect, this concept of fair hearing from our African practices to our African practices, as Nchiko stated, the Council of Elders, this practice was exercised to the pre-colonial, that is now the pre-colonial period. To during the colonial period, again, now the system's changed, and now we are at a period where we have gained independence, but we have the constitution by our colonialists. And we have these rights enshrined in the Independence Constitution in Section 21. But it does not specifically state that this is a right to fair hearing, but it gives tenets to what accused persons can experience, what the fair trial should look like. Then later on we have the repealed constitution now, which also gives a comprehensive detail of what fair hearing is, but then it gives limitations to this right. This right is not absolute. This means then it can be limited, and you can have a trial that is not. You can have a trial, but you have not experienced the right to. You have not. Hujasikilizwa kwa haki. Yeah. So. Then the 2010 Constitution, our very transformative Constitution, bridges this gap of now, or the gap of having a right to fair hearing that is not absolute. Article 25 redresses this, making the right to fair hearing absolute. Great. And then we also have some of the rights, some of the tenets, like the right to legal representation. It's been made now. Every accused person has a right to legal representation. So in the repealed constitution, our previous constitution, we had the right to legal representation, but it was really limited in section 7714, subsection 14. It actually limited it and stated that you cannot use legal representation to say that your trial was not fairly done. So the 2010 Constitution has really given a detailed outlook of what fair hearing should look like. And it's an interesting moment that we are now discussing on 15 years later. Have you been able to experience the right to fair hearing? When brought before court, are your relatives, the people around you, able to experience the right to fair hearing in courts? Because again, as we have stated, this is what enables us to seek redress when it comes to substantive rights. I hope to hear from you. What about undelayed trials? How long are trials taking? And what, in your opinion, is a trial that is within the timelines that would serve you justice? Yes, thank you so much. I hope to discuss this with you.
Thank you very much, Miriam. As you can see, we've really rushed our presenters. Apologies for that. She's posed a question. When the Constitution talks about speedy hearings, how, or rather unreasonable, without unreasonable delay, what timelines are there? So I would want to hear from you. Probably could just pick 3 quick questions. It's you people who are now stopping us from going to lunch. So 3 quick questions.
Thank you very much. My name is Rafiq Mohammed from Credible Investment in Nakuru. I'm very glad to be here because I just had a very sincere opinion on that article that Rosasi has just mentioned, because I believe that Article 132 is talking about AJS, access to justice through the other means. And that one is bringing the question of what she's just mentioned, that delays in the capacity for state to address so many law cases. And we are talking about the civil and the criminal cases. And this actually defeats the Article 50, which means as much as it's suggestive, I would like to see that reflection going to saying we have 15 years. How long will it take for us to be actually mature as a constitution? And I think this constitution should now be reflecting the young age of Kenyans. Because if you take it from that perspective, that 15 years down the line, we are still debating on AJS as if it is something which is supposed to be transitional. We should actually be mature now to say, this is a structure that the state should release to the people and then focus on matters that would enable this country to move forward. And with that, thank you very much.
Thank you very much. There was a question somewhere. I think it's more of a comment, but Rosasi, you could weigh in.
The question is, at 15,
yeah.
Are we saying we are still delinquent? Or are we saying we are mature enough now to move forward?
Yeah.
Or where is the gap? What is happening? Yeah. I think the state should now relinquish these resources to stop making it become a state function and release
more AJS.
Yeah, release this energy to the lower status of applying justice.
Thank you.
Otherwise, the article is defeated. We will not be talking about that article. It should not exist. We should just say it's defeated.
Kazi kwako Rosasi. Yeah. Let's take another round, then we'll get to yeah.
Hello. Yeah, thank you very much. So Kihara Steven is still my name, representing Center for Enhancing Democracy and Good Governance. That is said GG CSO in Nakuru. Thank you very much, my brother Rafiq. Yeah, at least you've seen me now. So also mine, I have 2 main concerns. Basically, first, in accordance to Article 48, which has been clearly stated or articulated by, I think, Mr. Christian Rugenge on the access to justice. We usually say, we as HRDs, justice delayed is justice denied. And that actually has been like, we can say, the contemporary animal in the house nowadays. Nowadays, justice, for you to get justice in this, our beloved Republic of Kenya, ni nadra, ni ngumu sana. Ni ngumu kwa nini? Because unaenda kotini maybe, unaambiwa kesi yako inahitaji evidence. Evidence! Yeah? Mtu Mkenya wa pale chini ya grassroots community local member ajui evidence ni nini, ndiye anasikia mara ya kwanza how to submit evidence before this honorable court. Yes? Because a magistrate or even a judge hawezi rule in any case without any evidence. And most especially I want to talk about the contemporary issue that we are having of defilement cases. Yeah? Many of our community members in the grassroots level wanaumia. Wanaumia kwa sababu ya nini? The government or the state does not provide enough, capacity building to the community members on how, to present their evidence before the court. So I just want to ask a very direct question to the panelists to answer me. To what extent am I correct to say that to some extent the judicial system, our judicial system, is compromised by the executive, or rather by those in the political leadership?
Thank you. That's the first question.
Yes, the last question, but not least, is on the Article 49, which was presented very well by Ms. Esther Mwikali. Also, to what extent, and before I say that question, I expected much more consideration on the previous demonstration that we had. In accordance to what we've discussed earlier on yesterday, Article 37, which has actually guaranteed on the freedom to demonstrate. And this on the Article 49, right of an arrested person. So basically I expected more articulation in the previous demonstration that we've had. So my question very straight is on to what extent as well will I be correct to say that most of our duty bearers are basically, we can talk about specifically the police officers that we are having, are supposed to be taken back for continuous, or rather to be engaged for continuous training on upholding human rights, as well as the stress coping mechanism. Because we've seen a high number of rising, whereby our duty bearers, most especially the police officers, they have mental health issues. Thank you very much.
Thank you.
I beg to sit down from there. And lastly, we need to fully implement our Constitution of Kenya. Not to amend, because we've seen several politicians trying to amend, most especially this article, from Article 37 up to Article 49. So thank you very much. I beg to sit down. That's my submission. Thank you.
Thank you. So an issue around implementation, and I think it cuts across all the articles. I think we can go by that. So my panelists, very quickly, I'll give you a minute each just to make suggestions on the questions, because they all relate to the 4 articles. So we could start with you, because you have the microphone, Miriam.
Okay, so I would like to comment specifically on what he asked on how long will we take to reach maturity. We are 15 years after the Constitution of Kenya, and after the enactment of the Constitution of Kenya, and now how long are we taking to get there, to experience these rights? And for me, I do believe that, number one, we enacted this constitution, this very transformative constitution, but with the people who are implementing it actually have a colonial mindset, if I'd say. And we have systems, but the systems do not work in our favor. And for example, the judiciary, the alternative justice system program, which would really help in terms of reducing backlog. And also it's the one that we relate to as Africans. And the state should dispense funds to the judiciary to ensure that this system is implemented. But there is already underfunding. Even before we have this AGS program, we already have a problem of underfunding. We have a situation whereby if the executive is to fund us, we have to compromise at some point. So we have a very transformative constitution, but with very, we have to change, I think, our mindsets. And as Professor John Osogo-Ambani says, it's a process, it's progressive. We will not tire, we will continue to fight for our constitution. Yes, thank you.
Thank you so much, Rosasi. To try and answer the question about our duty bearers, more specifically our police officers, yes, I do agree with you. It will be very beneficial to the country if they underwent training on how to uphold human rights. This behavior by our police officers is tainted by colonial legacies. But now that we are, I think, over 50 years since independence, we need to start looking on ways to reform our police services. We're supposed, I would agree with that suggestion that they need to be trained on how to process the arrested people. And there's also the question on parading them, holding banners that state the crime of a particular person. Maybe to add something on the right to fair hearing, one component of the right to fair hearing is the presumption of innocence. So when an accused person is paraded with that banner stating his offense, it's like the police have already presumed that the person is guilty. So yes, we need to undertake a training, a reform in the police service. Thank you.
Yep, so I'll try to answer my brother there. I did not get the name, so I'll avoid to massacre his name. So like, he started with the quote, justice delayed, justice denied, and also apart from that, he wanted to know like whether the judicial system in Kenya is compromised by the executive, if I'm right. So like what I can say, the way I understand access to justice is there are certain rights and people are entitled to those rights, but not everyone knows they have rights in this country. And it requires, like, people have to be educated about their rights. That's why we talk about legal awareness. And it's not only on the judicial department, if I can say so, but even the constitution mandates the state, and the state has three arms of government: the executive, the judiciary, and the legislative. So like, these are shared responsibility to ensure in Kenya each citizen know their rights, they know they have access to justice, and it's not only on the judiciary. And when it comes to the judiciary, I think we have people like the former Chief Justice Willy Mutunga. They had mission of establishing, let's say, for example, in each county, an high court in order for people to access justice through the formal system. They have mentioned AJS, and I think those are some of the progress we have, even though we still have so many problems. And also, apart from that, is another thing I wanted to mention, because you said sometimes people will go and they don't even understand the entire requirement of the codes. And I think there's this thing called how do you pronounce the word? Epistolary jurisdiction. So when someone sends a letter to the courts, so you don't need to follow the entire process, the entire requirement. I did my judicial attachment, and you could even see, like, you have to start in the court registry, there are certain fees and all those things. But as a community, you can decide to send a letter, explain your issue, your problem, and why it matters to you, to the court, and the court will help you. Like, it's not a must anymore for you to follow the entire process. Just that letter will be sufficient. Apart from that, and you can even read Article 22 of the Constitution, which advocates for public interest litigation when it comes to such matters. Apart from that, another thing I may talk about is the fact that we always have open legal aid clinic in Kabarak on Wednesday, and people from the community will come and they'll learn about their rights. It's also another way of making sure you just come and they explain to you your rights. Like, I think I can answer that question in that way. And there's still some influence from the executive arms like in every other country, but we have to fight. That's the only way we can enjoy our rights. Yeah, thank you.
Thank you, Christian. So in a minute, Esther, what are your reflections? In a minute.
So yes, I do agree with you as in that the judicial system has been compromised by the executive. But I don't think it's only the judicial system. It's the judicial system, the prosecution, the police force, all of them. Because let's look at the Saba Saba protest that just happened. About 1,500 of the protesters were arrested and were charged.
Sorry, we can't hear you. I think there is a problem with the connection. Okay. I think the internet is failing us.
Charged with trumped up charge, and the bail was set because of that. Is it okay now?
Yeah, it's okay. Maybe in
okay
30
now?
seconds now. Sorry.
Oh, okay. So I was saying it's not only the judiciary, it's also the prosecutions, the police force, just everyone is like failing us. Because let's say what happened in the Saba Saba protest, 1,500 people were arrested by policemen. So these policemen like knew they're arresting people who are protesting, people who are exercising their rights, they have failed us. And after they've been arrested for no reason whatsoever, the prosecutors go ahead and charge them with these trumped up charges of like terrorism and robbery with violence. Again, a failure on their side. And after that, you see their bail and bond were set at like really high prices, and some were actually denied the chance to pay that. Now you see our judges, our magistrates, they have also failed us in that regard. And I do agree with you when you say that duty bearers should be taken back for training on human rights and stress issues. It's actually one of the reforms that I would suggest, that especially the police, that their training should be professionalized, and that the training must be overhauled to focus not only on discipline and obedience, but on service, rights, and community trust. Yes, I do believe that they should do that, because in countries like Rwanda and South Africa, there's actually like a shift in their police training. So their training, it emphasizes on community policing and rights-based approaches. I feel like another way we could also curb this interference is maybe by insulating the National Police Service from political interference, and by enforcing independence that has already been provided for in the Constitution.
Yes.
So yeah, I do agree with you. We have been failed, and these people should go back for training.
Thank you very much, Esther. So we want to bring it down at that juncture. I think I'm told lunch is now getting cold. So allow us to bring the curtains down. So with the exception of Esther, who is online, my three panelists have agreed to have a working lunch with those of you who would want to raise more issues. So at that note, I beg that we stop it at that. Maybe we could give them a round of applause as we prepare for lunch. Thank you.
And a round of applause for you, Mr. Lubala, for rushing that. Thank you very much, expert. Child rights, governance, save the children. Now we go for lunch. Eat to your full, because is it to your fill, sorry. When we get back, it's 3 panel discussions, mfululizo, yeah? So if you find one that's already in session, that's okay, but you have a right to eat. Just for those who are not sure what will be going on in the afternoon, this room, We will have a session on, the first panel will be on rights of persons detained, held in custody, economic and social rights. There was a lady who asked me about, when are we talking about education? This is the one. Interpretation of the rights now that deal with marginalized groups. And then the first marginalized group there, the special groups rather, children. That's the first one. The second one now deals with more of the special groups as per the Constitution, persons with disabilities, youth, minorities and marginalized groups, older members of society. That will be the second one. Alafu ya tatu, slavery and servitude, forced labor, privacy, state of emergency, Kenya National Human Rights and Equality Commission. So that's what we'll be doing in the afternoon. So enjoy your lunch. Bon appetit. Or is it chakula?